My name is Jesse Schley, and I am in my third and final year at the University of Pennsylvania Law School. Today, I have the pleasure to outline the important case of New York Times v. Sullivan for you. This case took place against the backdrop of the civil rights movement of the 1960s. A full-page advertisement entitled "Heed Their Rising Voices" was placed in the New York Times by supporters of both Martin Luther King and student protesters. The purpose of the ad was to solicit funds for Dr. King's defense on charges of perjury. The ad included several inches of small print detailing recent events in the civil rights movement, some of which were incorrect or inaccurate. The ad also criticized the police department of Montgomery, Alabama, for their treatment of protesters. Montgomery Public Safety Commissioner L.B. Sullivan, who was not mentioned in the ad, felt that the untrue words libeled him insofar as the ad criticized the police under his supervision. As required under Alabama law, Commissioner Sullivan sent the New York Times a letter demanding a retraction. The New York Times, through its attorney, expressed bewilderment at the request and replied seeking clarification. Sullivan did not respond to the request for clarification and filed a lawsuit in the state court in Alabama. A trial was held, and the judge instructed the jury that the case presented was one of libel per se. After deliberating, the jury returned a verdict in favor of Sullivan in the amount of $500,000. The New York Times appealed to the Alabama Supreme Court, which affirmed the judgment. The New York Times then filed a petition for writ of certiorari to the United States Supreme Court, which granted the petition. So, what are the constitutional issues in this case? First, the 10th Amendment and the concept of federalism. The concept of federalism is basic to our system of government. In a nutshell, it means that there are two government structures, the states and the federal government. The Constitution embraces this system, and the rights of the states are expressly preserved in the 10th Amendment, which provides that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This guarantee is generally referred to the reserved powers of the states or police powers of the states, as opposed to the delegated powers of the federal government. The sovereignty of each state continues in importance today. Much of the law and regulation that govern our everyday life comprises of state, not federal law. For example, the vast majority of criminal law is state law, and the definition of crimes, available defenses, and possible punishments varies from state to state. This case, New York Times v. Sullivan, presents another major area of law under state control, tort law, specifically libel per se. Tort law is the area of law concerned with civil, not criminal, wrongs. In a tort case, there is no possibility of the defendant going to prison. The goal of the plaintiff in a tort case is to obtain compensation for a wrong allegedly committed by the defendant. This case involves a defamation cause of action. Defamation is a tort in which the plaintiff must prove that the defendant communicated or published a false statement about the plaintiff which harmed the plaintiff's reputation. The general category of defamation includes slander, which is oral, and libel, which is written. Here, the newspaper's printed words are at issue, so the lawsuit filed by Sullivan against the New York Times is a tort action for libel under Alabama law. A special category of libel is called libel per se. That generally means that the words that were spoken or published were so outrageous that the plaintiff need not prove damages from the statements. Under Alabama law, libel per se exists if the words tend to injure a person in his reputation or bring him into public contempt. The trial court found in showing that the falsities were published by the New York Times, this standard was met, and the paper's only defense was to establish that the publication was true in all respects. In considering Alabama's rights in this case, keep in mind that it has the authority under the 10th Amendment to create tort law as it deems appropriate. Finally, this case invokes the First Amendment's freedom of speech and the press. The First Amendment to the Constitution states in part that Congress shall make no law abridging the freedom of speech or of the press. Beginning with the 1925 case of Gitlow v. New York, the Supreme Court has proceeded to find that the Due Process Clause of the 14th Amendment carries over all of the guarantees of the First Amendment onto the states. Therefore, Alabama is obligated to make no law which abridges the freedom of speech or the press. With that outlined, Those representing the New York Times should consider why freedom of speech and the press still exist and the role it plays in our society. Those representing Sullivan should argue in favor of Alabama's right to provide him with a tort remedy where untrue statements concerning him were printed. Both sides should develop arguments to support your position.